Good morning.
Morning.
My name is Amanda Rivera. I'm the hearing examiner presiding over today's case. The date is October 5th, 2023, and this is case SEZ2021-00024. It is a request for consumption on the premises in St. James City in the Pine Island Community Planning District. Because this is a quasi-judicial hearing, all evidence and testimony must be taken under oath. So if you intend to speak, if you could please raise your hand. Do you swear or affirm the testimony you will provide is the truth?
Yep.
Thank you. I think everyone here is familiar with the process. Is that correct?
Yes, ma'am.
Okay, then I'll dispense with the instructions and we can begin with the applicant whenever you're ready.
Madam Hearing Examiner Keith Long for the record on behalf of the applicant.
Thank you. I'm sorry, if you could please come to the podium.
Oh, yes,
We're
ma'am.
broadcasting now, I apologize, and so the
Yep.
capture doesn't go all the way to the
Every
table. Thank you. Good morning.
Good morning, Madam Hearing Examiner staff. For the record, Keith Long, Long Law, on behalf of the applicant in this matter. This request that we have before you today, I think the staff's done a wonderful job of putting together a report. The applicant is requesting for a approval for a special exception in this matter. What's essentially the basis of the request is that the applicant has for many years, upwards of, I believe, 15 or 20 years, and under various ownership, has established a restaurant on the premises that you see before you in the aerial. And they have been operating in that district harmoniously with the neighborhood for many years under a 2COP beer and wine consumption on premise, and that's for both indoor and outdoor, which was granted to them under a previous zoning resolution, I believe, before this department. What they're now requesting is to increase their offering from beer and wine to beer, wine, and spirits in conjunction with a full-service Group 3 restaurant on the site. What that essentially means in reality, as far as an operational standpoint, is that the operation remains the same as a Group 3 restaurant, where they are obligated per statute as a condition of the license that they're going to be operating under, a 4COP special food service license, to maintain at all times 51% or more gross revenue from food and non-alcoholic beverages. And that's a qualification, and that's subject to audit from the state on an annual rolling basis. So there is some oversight in that regard. So what that means is basically it's an addition, a different bottle on the shelf. The operation remains the same, inward and outward. And so what I refer to when presenting a request such as this is that it's a benign use, in our humble opinion. It's not a situation where we're requesting a full bar license, a quota license, where it's unrestricted alcohol sales. And I think sometimes when I do present these sorts of cases in different geographic areas, in a more dense city, there's concerns about overconsumption and the type of establishment that it would become. But I think because of the geographic limitations of this particular parcel being where it is out on an island, this is more of a community restaurant that services the direct community. And so it's unlikely that the addition of spirits in this case, in addition to the full service restaurant, is going to bring a different crowd or create a different dynamic. I think it's just an additional offering to be able, for the applicant to be able to provide to their diners. And so with that, I would submit myself to any questions. I know staff's got a brief report as well.
Just a few.
Yes, ma'am.
The COP plan was a little difficult to read, so that may be obvious, but I couldn't discern it. Is there a marina? Is it associated with this site? So you're serving the traveling public by boat and by land?
That's correct. Yes, ma'am. Now, you don't operate the marina, is it?
No, we have dockage.
The docks,
on
yes,
site,
ma'am.
But we don't operate a working marina.
Okay, but folks that are on the waterways are able to access you from
Accessible,
one of
yes, ma'am.
those? Okay, thank you. And there's no expansion to the footprint that's
That's
actually
correct.
being proposed. What is, I'm assuming this is like a gravelled area to the south that's shown where it's open. Is that the parking area?
Yes, ma'am. That's additional parking. That's under joint ownership from the applicant.
Okay, and was a detailed site plan showing the parking, was that provided to
Yes,
staff?
ma'am. It was. I have a copy here if you'd like, but it's in the staff report and it should be in the record.
Okay, I didn't have it, and it's just a requirement of the application. I have the site plan, but I didn't see any
The
calculations.
detailed parking plan that they provided was not really that great. It was hand-drawn,
Okay,
That's
wiggly lines, and
but it met staff's sufficiency review.
has been around since 2021. It was about time to take it to the hearing.
Okay. And
I did the hand drawing, so it is a gravel parking lot, so I tried to designate, slots based on square footage and all of that. But
working with what you've got, I'm sure, and I appreciate that. Do you know, this is a very basic question, what's the size of the two parcels? I couldn't find acreage anywhere in the materials. I saw the legal description was two platted lots, but
between the two lots, it's about 3/4 of an acre.
3/4 an acre total? Okay, thank you. And have there been any reported issues with the operation as it's been, with just the beer and wine licensing?
Not to my knowledge.
Code enforcement or sheriff's office knows violations, nothing of that?
No, ma'am.
Typically, what we do in matters like this, like I said, when I anticipate those sorts of questions, is I will request incident reports from the sheriff's department, and there was nothing of notable concern when that was brought forth.
Excellent, thank you. That was the extent of my questions at this point. Thank you.
Thank you, ma'am.
Ready for staff whenever you're ready,
Okay.
Sharon.
Good morning, Sharon Badamchian from Lee County Zoning. My resume is on file. I was recognized as expert in zoning and planning issues. I would like to be recognized as such at this time.
Yes, thank you.
Thank you. The request is to upgrade an existing liquor license for a restaurant. And they had this license, we could go all the way to 2008, which they did a special exception to legitimize the existing outdoor seating. So I don't know how far back it goes. That's how far back I could track. Has been around for 17, 18 years at least. There is a single-family house within the 500 feet. Actually, it's 240 feet. This is the house. 240 feet from the outdoor consumption area, but it is separated by a wide canal. It's not like people, they're gonna walk there to people's backyard. And with that said, they had two special exceptions approved in the past. One of them had several conditions about landscaping and buffering and all. And when I made the site visit a long time ago, it was like after the hurricane, and I couldn't figure out what is done, what is not done. It's like there were debris everywhere. So I kept the conditions saying that whatever was approved, they have to still comply with that. I didn't know if they complied but was destroyed, damaged, or they never did. So that's the reason the condition reads the way it reads, that I didn't want to add a new condition. I just said the condition of the resolution 2012-00088 still applicable.
That was my primary question, because when I went through it, it wasn't clear to me either. And as you know, we don't usually like to reference back to something else and then make people hunt and peck around when they're looking at it. So I'm okay to retain them, but move them in. I don't want to just make a reference to the prior COP, because I do think folks have a hard time
We can
locating
do
those.
that, that's fine.
But does the
An applicant will be amenable to incorporate in those.
Okay, so you're okay with them staying in as they were previously written in the 2012 version as they are? Okay, do you have any indication if any of them had already been?
My understanding that they were in compliance with all of the conditions for the last several years of operation. If what staff is alluding to, it is more likely than not to be correct as far as the landscaping as being a result of the hurricane, if there was anything that was not. But again, for the record and moving forward, applicant would have no problem moving forward in compliance with the pre-existing requirements of the special exception.
Okay, because there's a few, just going through them while we're here, it made reference to it becoming null and void with, I mean, some of them, they can just be dispensed with because they've obviously been complied with, but there were some about filing for development order for the redesigned parking lot and buffers. I'm assuming that had to have been done
Yes, ma'am.
long ago, so I don't want to, the point is, we try not to condition things that have already been complied with because it's just not sensical, but the testimony I'm getting is that no one seems to know what's been complied with or not. So I
Well-
don't want to just make a blanket reference, because as it's written, it says except as amended, but it's not even clear which ones were amended. except for the site plan and the hours of operation. So you're basically bringing everything else forward, but some of them have obviously been complied with if you've already gotten the development order, because then you've got to be
We would not have
compliant with
gotten
the
this far
development order.
otherwise. Yes, ma'am, that's a correct assumption, I think.
Do you know the development order number? I could make reference to that if
I
it's
don't have that
inactive.
information available. If you'd like to leave the record open, I could follow up with that if that, you feel that that would be necessary.
Is it an active development order that you're still
That I'm not
working
aware of.
under?
This applicant himself has owned the property for, I believe,
2.5 years.
2.5 years, so that would have been a pre-existing requirement, so he wouldn't be intimately familiar with that process, but I could certainly search the,
Okay, that might be the easier way to move forward, because if there were any plantings or things that need to be restored, that would be pursuant to the development order, and if you're still being held to that, then that can be brought forward. But I get my discomfort, it's just I wasn't sure reading this, and if I don't understand it, I know somebody else
Yeah.
picking this up is not gonna understand it, so I don't wanna just have a blanket. They have to comply with things, and then you guys are gonna have a problem down the road when you come in to know whether you're in compliance with it or not, so I just wanna flesh that out a little bit. So do you have them in front of you, Shram? Can you go through them, the conditions, and just explain which ones you would
Well,
like to
it
remove?
was mostly the conditions that I was worried about was about the landscaping and buffering.
Okay,
And I just couldn't figure out which one they have complied with, which one they haven't. Because the area was not in great shape when I visited there, and I went through the files and I couldn't find much. So that's why I kept it the way I did, saying like whatever they have not complied, they have to comply with now.
so the buffers, so condition 9 is what you're referencing, everything under
Correct.
condition 9 you would like to see brought forward, and the applicant didn't have objection to that?
for the buffer requirements in
Right.
condition 9, no ma'am, from COP 2012
Yes,
00088,
that's right. So it's under A of the
see it.
conditions.
Page 2, yes ma'am.
That's right. So the outdoor seating area, the site plan obviously will be updated. That's not an issue. We don't put the expiration dates on there anymore, so we don't have to worry about 2. And your testimony was you already had a development order under 3.
That's my understanding, yes ma'am. I would like the opportunity to leave the record open to follow.
Yes, I will do that. And then for 4, I assume, again, you've made reference, it's the DBPR. I assume that still retains licensing authority over that. So whatever state requirements you had to do to adjust, I'm assuming, again, that's
That is correct.
been over 10 years, so I'm assuming that that happened. 5, Sharon, that was one where they were limited to the Group 3 restaurant, a total of 60 seats. Is that still a limitation that you were wanting to include?
Well, they didn't give us number of seats indoor and outdoor. They said everything is staying the same, so yes, I want.
Yeah, I'm sorry.
But this is why I didn't want to have any of the confusion. If that's not the intention, though, if staff looked at it as the square footage and not seats, we don't need this in here anymore, and I can just get rid of it. If staff,
Well, the way they did the application, they said we are not changing anything, everything is staying the same. So if everything is staying the same, then
That's correct.
okay.
But it's also correct, I mean, typically you would see just a blanket square footage, and then the life safety plans and the fire codes, et cetera, would delineate how the seating would be conducted.
And that was, and it's all tied to parking ultimately, and that
Yes,
was
ma'am.
my question about the parking, because I didn't have the detailed parking plan with the calculations. So I, generally I don't want to get into the weeds this much in the
Yeah,
hearings,
no.
but I didn't have the information to go do this.
Yeah, the parking is tied to
Prior.
the square footage and then the use, of course, so I
Right.
believe, Sharam, I believe it's 14 per,
for house.
yeah.
Okay, and then the hours of operation previously were 7 a.m. to 11 p.m., but now it's 11 to 11. So is that amenable with everybody?
Does that work, or did you want to?
No, that's
Okay.
what we intend to run.
Okay, and then the outdoor entertainment, are those hours staying from 5 to 9 and then 2 to 6?
Yes, ma'am.
And prohibited still on the northern and eastern dock areas?
Pardon me?
It's prohibited on the northern and eastern dock areas, that's still all correct? Okay. And then there were 6 parking bumpers, it looks like, that had to be located. They had to remove them that were previously located within the right-of-way. I assume also that that has been done long ago. Okay. So that helps me. So I can do cleanup work there and just carry over the ones we discussed that are still applicable, including the buffers, but I'll leave the record open so that you can
Please.
provide the information
Yes, ma'am.
on that development order to ensure that you're okay with all of that. If you could coordinate with staff so that you can give me a unified filing after the
happy to.
fact, that would be most helpful to me, so then I know everything's good. Let me go through my notes. I believe that was the extent of my questions. Did you have anything further, Sharon, that you
No,
wanted
ma'am.
in your presentation? Okay. Okay, did the applicant have any final comments or closing remarks?
No, ma'am. Just that I believe Shram touched on it as well. I forgot to mention, obviously, the buffer is the precipice for this whole thing, and so the single-family residential dwelling to the southwest has certainly been in existence alongside the restaurant's operations for many, many years, and there's never been an issue with noise or otherwise that the applicant is aware of or myself through searching the records. And so I just wanted to make sure that I got that on the record as well.
Thank you.
Thank you.
And for the record to be left open, how much time would you like to do that? By the end of next week?
Yeah, that'd be more than enough, I think. It's assuming that I'm able to easily access those records. If not, I believe that with the assistance of staff, we should be able to pull those relatively quickly, and then we'll have our answer.
Okay, perfect. So I'll leave the record open till end of business on October 13th, and if more time is needed, you can always request that from my office, and if it's in sooner, then I can review it sooner as well.
We
So
certainly
whenever
will.
that gets to me. Thank you. And this was, just to clarify again, this attachment F, this was a site plan that you
Correct.
wanted to be included? Okay. Okay, well, thank you. Thank you, everyone, for coming this morning. I appreciate your time.
Thank you so much.
Please stay well and stay safe out
Oh,
there,
yes.
too.
Thank you for your consideration.
Thank you.
Thank you.